Thank you. It's great to be here. If you have any problems hearing me, let me know. Hopefully you'll let me know. Chocolate milk on me too, but I can't live a 2-year-old. It's just me. It's been a long day, but I really look forward to speaking to different groups across the state, particularly on this topic and constitutional issues. Just briefly, I don't need to tell you any more about me. I think that was great. Thank you so much for the intro. A little bit about the John Locke Foundation. We're a kind of a think tank here in North Carolina. We focus on North Carolina issues primarily. I'm part of the research division, and what we do is analyze issues. We do op-eds, we write reports, we testify before the legislature. We try to help shape public policy in North Carolina. And I think our principles are probably consistent with your principles. So I do hope that you would take a look at what we're doing. And we also do the newspaper. We publish a newspaper called Carolina Journal. And every day, it's in print. And it's really kind of the only newspaper in the state that kind of has at least some, it's not quite as biased. I know you know that Raleigh News Observer and these other papers are biased, you know that. But I think the Carolina Journal is a little bit more fair and balanced. And there's a lot of information that you may not actually hear because the mainstream media may not want you to, or may not report on some of those issues. So I encourage you to get a copy of the Carolina Journal. It's free. You can also sign up to get the daily Carolina Journal that was mentioned before. Every day there's headlines on what's happening in the state. There's a column, there's all kinds of interesting things going on. So we're doing a lot of exciting things at the John Locke Foundation, and really we're, I think, kind of the voice when it comes to conservative, limited government principles in the state of North Carolina. Certainly focusing on kind of the constitutional issues. We believe in individual rights, limited government, and of course free markets. Really focused on kind of the free market issues. And today, I'm going to be talking about whether or not it's the end of the road for Obamacare. And if you have any problems seeing this, most of the slides, the font is pretty big. There might be a couple of slides where the font's a little too small, but I'll try to read some of it. Anyway, again, thank you. Here's my game plan for tonight. And by the way, I do look forward to taking questions from you. If possible, I prefer to just kind of present right through, and then you can ask the questions after. Unless it's just something you just have to ask me, or I've offended you in some way, then you can go ahead and interrupt me. That happens. I'm going to provide some brief background. I'm going to address some of the red herrings that have been made by proponents of Obamacare and try to just slam them. Because there are some arguments that just make no sense. I'm going to get into some of the constitutional issues that exist as it relates to Obamacare. Then I'm going to tell you what's happening, in the courts and where we are in terms of whether or not Obamacare is going to get struck down. Is it not? Is it going to be constitutional? And let's get started. So Obamacare, also known as the Patient Protection and Affordable Care Act, and we just call that Obamacare, was signed into law in March 2010. And what it does is it mandates that individuals buy health insurance. So you have to buy health insurance, and if you don't, you pay a penalty. And that penalty will be collected by the IRS starting in 2014. Okay, so this is what's referred to as the individual mandate. And a lot of the legal challenges that exist focus on this individual mandate for the most part. Whether or not this mandate for you to have to buy something is constitutional. A little background, not everybody has to comply with this mandate. There are some exceptions. Some low-income individuals don't have to. Individuals who object to health care coverage on religious grounds, and it's kind of narrow exception, but I don't know, maybe you could create a religion and object to it on religious grounds. I don't know. And illegal immigrants, which is kind of interesting. And I should point out, as it relates to illegal immigrants, if we think, well, of course illegal immigrants wouldn't be mandated to buy the health insurance, well, that's actually not true, because illegal immigrants, as probably all of you know, some of them do pay income taxes. And we have something called what's called ITIN, an Individual Taxpayer Identification Number, which is designed to allow legal immigrants to pay taxes, and the IRS doesn't, deport anybody, and doesn't tell ICE who deports people. So we do want to collect the income taxes if they're here to the extent that we can. So it is possible to have mandated that they buy health insurance. So it would have been impossible. It would be possible because the IRS could then simply impose a penalty on the illegal immigrants. Of course, what would happen is the illegal immigrants at that point wouldn't want to pay the income taxes anymore. So that's really the reason why they don't have to worry about the mandate. So really the big question is this, and this is what it comes down to. I'm not going to talk about policy in a way. I'm going to talk about law. I'm going to talk about principles. I'm going to talk about the Constitution. I'm not going to tell you whether or not I think the individual mandate is good public policy. I don't. But does Congress have the power to require such a mandate? That's the question. Well, let's think. Let's look at the law. Yeah, I hope I didn't scare anyone. Yeah, I don't really have to say anything about this up. There's Nancy Pelosi.
We have to pass it before we find out what's in it.
Well, that's right too. So she's asked from a reporter, where in the Constitution do you have the power to enact the mandate? What's her response? Do you remember? Here's what she said. Are you serious? Are you serious? And then the press secretary later had the same comment. That's not a serious question. It's not a serious question. Apparently, serious was a word of the day there for him. So, you know what? Yes, it is a serious question. In fact, it is the most important question. In fact, it is the question. Let me go over some red herrings first. We'll get back to the constitutional issues. Okay, Massachusetts has actually an individual mandate. That's no different. And I kind of got the answer there, but why is it different? Exactly. So anytime you hear, well, Massachusetts has the individual mandate, well, there's no constitution. Well, there is a constitution in Massachusetts, but that has nothing to do with powers of Congress. So remember, this is about congressional power, not a state issue. So that's a red herring. It's no different than a state requiring auto insurance. Well, again, we get back to the issue of, and by the way, who made that argument? At least in 2009, Obama made a comparison to the mandate, to the individual health care mandate, to auto insurance. I don't need to read the whole quote, but you can see that right there. So that's supported there. Well, first of all, we know it's a state versus a federal issue. But you don't have to buy auto insurance. I mean, you may say, oh, well, practically I do, but you really don't have to buy it. You only need to have auto insurance if you intend to drive on public roads. So if I got my car and just drove around this parking lot, I wouldn't need to have auto insurance. I wouldn't even need a driver's license. And there's kind of some other policy reasons why we may want to have individuals get auto insurance as opposed to the situation with the health insurance. For example, it's a license on a public road, so there is some reasonable basis for government to protect the people on this road. All right, so those are the red herrings. So you can easily kind of get into those easily. It doesn't mean that people aren't maybe debate, or people might come up to you and they may make those arguments. So it's good to just have those at the ready and be able to counter it. So we looked at the 10th Amendment. The 10th Amendment says basically power is not delegated to the United States by the Constitution. Basically, the states have that power for the people. So getting back to the original question, does Congress have the power to impose the individual mandate? And where do we, if I kind of ask you questions like I'm teaching a class, sorry about that, because I kind of just got done with the class. this comes as a surprise to Congress and to Nancy Pelosi, apparently, but Congress can't do whatever it wants. Basically can, unfortunately, but it can't. If we really follow the Constitution, it really could. What we look to figure out legislative power, the power of Congress, is Article 1, Section 8 in the United States Constitution. So let's look there. And it's something called the Commerce Clause. And Congress has the power, and this is the language, to regulate commerce with foreign nations and among the several states and with the Indian tribes. The main focus of whether or not Congress has the power to impose a mandate is going to be whether or not Congress has the power under the Commerce Clause. Now, if you look at this language, is there anything about intrastate commerce? In other words, commerce within the state? No. But unfortunately, the Commerce Clause, for centuries actually, has been expanded to mean almost anything. We gave Congress almost any power they want. And they can regulate intrastate commerce if it has an impact on interstate commerce. So that's what I have here. So under the Commerce Clause, Congress does, at least as the Supreme Court has read it, Congress has the power to regulate interstate commerce, commerce between the states, and it can regulate intrastate commerce if it has a substantial effect on interstate commerce. Very broad powers. So, can Congress regulate health insurance? The answer is yes. I'm not saying if I went back and interpreted the Constitution the way I think it should be interpreted, that's what I would conclude. But given we look at past cases, what the Supreme Court has said, the answer is yes. It's certainly an interstate system. It's certainly, even if it's interstate, it has an interstate.
What do you mean, the way you interpret the Constitution?
In other words, if the Supreme Court had interpreted the Commerce Clause to mean something that I don't think it means, they've expanded the congressional power way beyond what I think the language of the Constitution says and way beyond what the intent of the Constitution says.
But that's how you interpret it, right? You said you personally interpret it that way?
Interpret what?
The Constitution.
In what way?
Well, you said, the way in which you interpret the Constitution.
Yeah, well, the way I would interpret it is you certainly have Congress has the power to regulate interstate. That's clear. As it relates to intrastate, probably not. It would be very limited scope, very limited power if I was to interpret the Constitution, and also to look at the intent and also history on it. And you'll see how far the Supreme Court has gone, and I'll make it very clear that I don't agree with those opinions. And this is the extreme cases. These are a couple of extreme. I'm showing you what I think are the most extreme Commerce Clause cases, because that gives us a chance to see, put it in context, how far the individual mandate is going. There's a case from 1942 called Wickard versus Filburn. It involved a case where it's the federal regulation. You have a wheat farmer in California, and the federal government wanted to regulate this individual and his personal production and consumption of wheat. Now, this farmer was not putting the wheat into the stream of commerce, but the fact that the farmer was consuming wheat on his own and therefore not buying wheat on the interstate commerce or in the market hurt the interstate market for wheat. As a result, Congress had the power to regulate this farmer. That is an extreme case. Okay, the person's not even engaged in any type of economic, commercial activity. It's called an activity, but he's not affirmatively engaged in commerce here. So I would not have ruled that way. Unfortunately, when the Supreme Court had a chance to go back and reverse that absurd case, very extreme case, in a case called Gonzalez versus Rage, they didn't do that. In fact, they kind of supported what the Supreme Court said. They said that Congress has the power, under the Commerce Clause, this is all Commerce Clause cases, they could prohibit individuals from growing medicinal marijuana for their own personal use. And the reason why is that that can have an impact on the illegal market for marijuana. So even though it's a personal use, and I'm not going out and buying medicinal marijuana or anything like that, the fact that it's just for personal reasons, somehow that has some type of commercial impact, because I would, if I wasn't growing it for personal use, I don't know, I would be buying drugs illegally in the black market of medicinal marijuana. So even in that situation, Congress has the power to regulate at least medicinal marijuana. Now, this is what I say here. It doesn't matter if somebody isn't engaged in commerce. If a person affects commerce in some way, and that's what we're saying, if you affect commerce in some way, then Congress can regulate. But there's a big difference between these cases and the individual mandate. I mean, these cases may make you think, oh my gosh, how can you distinguish between the individual mandate and the farmer case and the medicinal marijuana case? Well, it deals with activities. Under the Commerce Clause, Congress can regulate activities that affect commerce. And the word activities exists for a reason. And this is just Webster's dictionary, what the word activities means. This is what lawyers do. The quality of state of being active. What does an activity mean? We know what an activity means. Being active means to, energetic action, liveliness, alertness. Do something. That's what it means. So what was the action or the activity in the Wicker case, the one dealing with the farmer? Well, just because the farmer, yes, the farmer was not buying wheat on the market, but the activity that Congress was regulating was the individual they're regulating the farmer who was growing wheat. The action was the growing of the wheat. So Congress was regulating an activity. In the race case, the medicinal marijuana case, it was growing marijuana. So the individual was, in fact, engaged in some type of activity. This is important because this is what this whole fight against individual mandate is all about. What is the action with the individual mandate? What action is somebody taking in the individual mandate? If I require you who are not buying health insurance to buy health insurance, what activity am I regulating? Nothing. I'm not doing anything. You're regulating me for not doing something. That's the difference. That's how we distinguish the case. And this would take Commerce Clause jurisprudence, the cases, to a whole different level. Congress basically is regulating inactivity. Not activity, but inactivity. Congress would be regulating you simply because you exist. That's what Congress would be doing. And as I say, Commerce Clause is about regulating commerce, but with the individual mandate, Congress isn't really regulating commerce at all. In fact, what they're trying to do is create commerce. They're trying to force people who are not engaged in commerce to engage in commerce, to buy health insurance. So what would be the practical implications of that? If Congress can mandate that you buy health insurance, why can't Congress mandate that you buy handguns, sports utility vehicles, large houses? I talk about gym memberships. In fact, if it's good for business, why can't Congress mandate that you start a business? Or mandate that kids sell lemonade every weekend? There's no logical limit to this. There's no way. If Congress can force you to engage in some type of commercial activity, then what makes health insurance so different than anything else? There's no line. There's no logical distinction.
Kind of like the fluorescent light bulbs?
Well, they're prohibiting you from buying it, as opposed to, now if they decided that you actually had to buy fluorescent light bulbs, that would be more akin to what we're talking about.
Yeah.
Now, the fact that they prohibit the light bulbs from being sold, being sold, just from a policy perspective, think about the implications of that. So then you go to the different light bulbs with a mercury, you know, and think about, you probably have so much more problems when people drop those light bulbs and have to deal with the mercury cleanup. See, usually we talk about unintended consequences, but as far as I'm concerned, how can that be unintended consequences? It's so obvious, we knew that was going to be a problem. But that's kind of a whole different story. One reason why Congress shouldn't be in the business of dictating winners, losers, what should be bought, what shouldn't be bought. One counter argument. Erwin Chemerinsky, who's dean of Cal Irvine School of Law, talks about the 1964. He talks about the Civil Rights Act, and that prohibits hotels and restaurants from discriminating on race, based on race, and thus prohibits inactivity. Because the inactivities, you can't discriminate based on race. Therefore, I don't know, that's his argument about why we already actually have laws that prohibit, that already regulate inactivity. But the problem with that argument is that Congress is regulating inactivity under the Civil Rights Act. And that's the activity of providing hotel and restaurant service. In other words, if I'm a restaurant and I provide the activity of serving you and providing food or drinks, that's my activity. So there is an activity. And so providing that service to you, I can't discriminate against you. I can't decline to serve you because you're a certain race. That's not regulation of that's not a mandate or regulating an activity. One other basis for maybe allowing the individual mandate or saying the individual mandate is constitutional is under the tax power of the Constitution. That Congress has the power to levy and collect taxes. You can read it. It's not a tax. It is a penalty. The individual mandate is based on a penalty. In fact, the express language of the Obamacare statute, the language of the bill, if you go in it, it talks about it being a penalty. And then when you look at the bill, the whole law, there are other sections of the bill that talk about taxes, which is distinct from the penalty part. So it's clear that Congress intended the penalty to be a penalty, not a tax. There's a distinction. Not to mention penalty works different than a tax, just practically. That. There are some kind of details about how the direct taxes, and I don't want to get into too much of this because I think the tax argument, quite honestly, is really kind of a moot point. But if you can read it, you can kind of see that if let's assume that it was a tax, you'd have to kind of tax people in a different manner. You couldn't tax it individually. You'd have to base it on the census of each state, and it gets complicated. So they would have to change the tax, the